Mr. Mooppan?
Mr. Chief Justice, and may it please the Court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter, because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
So your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make, is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostick, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question, because under the regs, the question is, the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question and you should leave it separate, but the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place.
So
because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex for sports is the biological difference. And if you then undermine that, you've undermined the justification for separation.
So we're now back always to the science. Is there really a difference, and a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this. You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mooppan, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in this case.
Why not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.